The $15 million question. For the last 3 years, the estate planning world has been in a state of sunset panic. We were told that on the 1st of January 2026, the federal estate tax exemption would be cut in half, dropping from 14 million to 7 million. It was called the exemption cliff. But on the 4th of July 2025, everything changed with the signing of the One Big Beautiful Bill Act. Today, we're going to break down what that actually meant, what happened to the sunset, why your will using the old formula may actually be a ticking time bomb, and the new $15 million limit you need to know about. My name is Leon Jones Jr., and for over 15 years, I've practiced in both state and federal courts here in Arkansas. I've also worked for a Fortune 100 company, and I've held the positions as Director of the Arkansas Department of Labor and Executive Director of the Arkansas Fair Housing Commission. Now, I'm the Managing Attorney here at Big Rock Legacy Law Group, where we advise and represent our clients in business law, civil litigation, estate planning, and family law. Now, over these many years, I've had families deal with these issues, and I hope that this video provides you with some insight into how I provide advice to my clients, which is different for each and every client. So part one, the sunset that didn't happen, sort of. Under the old Tax Cuts and Job Acts, we were headed for a disaster. If you didn't use your $13.99 million exemption by the end of 2025, you were going to lose half of it immediately. However, the One Big Beautiful Bill officially repealed the sunset. Instead of dropping the 7 million, the exemption actually increased to a permanent 15 million per individual for 2026. So that means for a married couple, that's a staggering $30 million you can pass on tax-free. So the crisis shifted. It's no longer a use it or lose it panic. It's now a my will is outdated crisis. So let me explain why. Part two, the formula clause trap. Many of you have wills that were written 5 or 10 years ago, and these often use a formula clause. They say things like, put the maximum tax exempt amount into a trust for my kids, and the rest goes to my wife. The danger here is that when that was written, the exemption was only $5 million, but now it's 15 million. If your entire estate is worth 16 million, this old formula will automatically dump 15 million into a restricted trust for your children, leaving your spouse with only 1 million. Your spouse could be effectively disinherited by a tax strategy that was meant to help them. If you haven't updated your will since July 2025, you're likely walking into this trap. First, an outdated will can misinterpret or fail to take advantage of the new statutory defaults and definitions. The One Big Beautiful Bill refined fiduciary powers, updated default rules for survivorship, and it modernized definitions of descendants, issues, per stirpes distribution. So a pre-July 25 will may have language that is outdated, that can distort who takes, in what shares, and under what conditions. And it can complicate tax and administrative choices your fiduciaries would otherwise have available to them. Second, wills rarely operate alone. They should be synchronized with your beneficiary designations, with your revocable trusts, with any powers of attorneys, any advance directives, and any assets titling. When a will remains frozen in the pre-July 25 language, Arkansas language, or the Big Beautiful Bill has adjusted default beneficiary rules, spousal protections, disclaimer procedures, and digital assets access, the fiduciary accounting standards and your plan components can point in different directions. That inconsistency invites delays, expense, and avoidable disputes. Number three, there are direct legal and financial implications. A, if your will grants an executor powers that are narrower than or inconsistent with current statutory powers, your executor may need court orders to act, which can increase your costs and timelines. Conversely, if the will relies on cross references A court may construe powers conservatively, which could limit investments, it could create business continuity issues, or special asset management problems. B. Changes to Arkansas and federal tax coordination provisions can affect the formula bequests, marital or credit shelter planning, portability elections, and charitable dispositions. So pre-July 25 formulas key to exemptions or definitions that have since shifted can underfund or overfund trusts, distort spousal or charitable shares, and increase your overall tax and administrative burden. C. Modern statutes frequently expand fiduciary access to digital accounts, tokens, and intellectual property. Older wills may omit or inadequately authorize access, losing loss of value and administrative impasses. And D. Revised notice, bonds, and accounting standards can lower costs and delay, and your documents incorporate them. If your executor may face higher bond requirements or broader notice obligations or avoidable court supervision. So here are the 6 things that you need to know now and do that will erase the pain for your loved ones later. Number 1, conduct a comprehensive review of your will, revocable trust, beneficiary designations, powers of attorney, healthcare directives, and your assets titling to confirm alignment with the One Big Beautiful Bill and current Arkansas law. Number 2, update your documents. Restate or amend your will to incorporate updated fiduciary powers, definitions, construction clauses, and coordinating provisions. Confirm the formulas accurately reflect your tax and legacy objectives under the current law. Number 3, synchronize your designations. Update beneficiary forms or retirement accounts, annuities, and life insurance to match the revised plan and any trust structures. Number 4, address governance details. Refresh your executor and trustee selections, include successor trustees, clarify compensation, bond requirements, and removal provisions that are consistent with current statutes. Number 5, memorialize your intent. Add clear statements of intent where appropriate to guide construction and reduce disputes. Also, update your personal property memorandum that you would have gotten at your estate planning signing. And number 6, calendar reviews. Revisit your plan after major life events or at regular intervals, for example, every 2 to 3 years, or upon any significant legal changes to the law. The goal here is simple. Ensure your plan does what you want when you need it with minimal friction, tax costs, and litigation costs. Laws evolve, families evolve, assets evolve. A will that has not been updated since before July 2025 risks leaving your loved ones a legal puzzle instead of a clear path. By reviewing and refreshing your documents now, you preserve control, clarity, and the legal legacy you intended. To learn more about how we assist our clients with these and other legal situations, please click below to Let's Get Started today. Now, part 3, portability versus the Spousal Lifetime Access Trust, or SLATs, in the new era. With the $15 million limit, many mid-affluent families, those estates between $5 and $15 million, are asking if they even need complex trusts anymore. When the first spouse dies, the survivor can move or port over that unused $15 million exemption. Now, this portability rule is also known as the deceased spousal unused exclusion, or DSU, which gives the survivor a $30 million shield without any fancy footwork. However, for those seeing rapid growth in their businesses or in their real estate, SLATs are still the 2026 gold standard. By moving your assets into a SLAT now, you lock in the $15 million value today. And if that grows to $40 million over the next decade, that entire $25 million gain is completely tax-free. Number 4, don't forget about the states. Here's the gotcha. While the federal government just gave you a $15 million shield, your state might not be so generous. States like Massachusetts or Oregon still trigger estate taxes at much lower levels, sometimes as low as $1 million or $2 million. Even if you owe zero to the IRS, your heirs could still owe hundreds of thousands of dollars to your state capital. The sunset crisis may be over at the federal level, but state level tax creep is real in 2026. So now let's talk about your 2026 to-do list. Number one, check for formula clauses. Ensure your spouse isn't getting squeezed out by the new $15 million limit. Number two, review your state limits. Don't let the federal government win become a state government loss. Number three, growth assets. If you have assets that are about to explode in value, move them now while the $15 million limit is fresh. Don't put this off. Start with a simple inventory. Talk to your family and talk to your estate planning attorney, because the stakes underscore the need for professional guidance and coordinated planning. I encourage each of you to evaluate your situation early and often and discuss your unique needs with a qualified professional to secure the best possible outcome for you now and for your future later. If you found this video helpful, please hit the like button, subscribe to our channel to learn more valuable information about how we here at Big Rock Legacy Law Group protect our clients' legacy and advocate for their rights.